Welcome to the Data Practices Potpourri webinar with the DPO. Thanks for joining us. I'm going to share a little bit about our office. The Data Practices Office is a small office in the Department of Administration. We are a statewide resource on data practices and the open meeting law. Most of what we do is respond to questions about those laws from members of the public and from government. If you have a question about these laws, please feel free to reach out to us at any time. We also assist the Commissioner of Administration with issuing advisory opinions and provide legislative assistance and training. This PowerPoint is posted on our website, so if you aren't able to download a copy today, it will be on the page where you registered. We also record our webinars and post them on the Data Practices Office YouTube page. So if you missed part of today's webinar or want to go back and watch it again or find one of our previous webinars, you can do so on our YouTube page. I am going to share a file now for you to download the PowerPoint right now if you would like to. Okay, so a pop-up should appear for you to download the file. I know this doesn't work for everyone, so if this pop-up doesn't come up for you, like I said, please go to our website where you registered for this webinar and you should be able to find a copy of this PowerPoint there. Today's webinar is another installment of Data Practices Potpourri, where we highlight some of the questions we've received from data requesters and government entities. We'll leave some time at the end for a Q&A session, so please feel free to send in your questions as you think of them using the Q&A panel on your screen. Make sure you choose all panelists when you send in your questions so we can be sure to see them. You can go ahead and start sending those questions now or as you think of them, or you can wait until the end of the presentation. Let's jump in. Our first question is one that comes up a lot. Can a government entity charge any costs or fees when a data requester asks to inspect data? The answer is no. A government entity may not charge costs or fees when a data requester asks to inspect data. Inspection is always free. This applies whether the data requester is a member of the public or a data subject. Minnesota statutes section 13.03 and 13.04 set out that a data requester must be permitted to inspect data without any charge. An advisory opinion that might be helpful to look at is AO 10-024. That opinion dealt with a data request from a member of the public who was not a data subject. The requester asked to inspect data. After inspecting 473 pages of data, the requester asked for copies of 61 pages of data. The commissioner explained that an entity may not charge any fee for inspection. Thus, the entity could only charge copy costs for the 61 pages of data for which the data requester actually requested copies. Additionally, in the Deemers case, which I have linked on this slide, the Minnesota Supreme Court affirmed the determination that the city could not assess any charge for inspection of public data, and they could only charge actual cost if copies of the data were requested. Our next question is, do public defenders get access to private data about their clients? Public defenders do not automatically have access to private data about their clients. Chapter 13 does not provide greater access rights for public defenders. So they are treated like any other member of the public making a data request and will have access to public data. Public defenders may access private data about their clients with their clients' informed consent. For confidential data, public defenders can seek a court order to obtain access. I also wanted to note that under Minnesota statutes section 611.271, public defenders are entitled to free copies of certain data related to the defense of their client that they receive from court administrators, prosecutors, and law enforcement agencies. Next, we have a question about response time. In this scenario, a parent of a 13-year-old student requested data about the student from their school. How long does the school have to respond? The answer is 10 business days. The Data Practices Act requires that government entities respond to requests from a data subject within 10 business days. Because the student is a minor, the student's parents can exercise the student's data access rights. The parent essentially steps into the shoes of the student. Because they are asking for data about the student, this is a data subject request, and the school has 10 days, not including weekends and legal holidays, to provide the data. Our next question is about public data in personal email accounts. The individual asks, I volunteer on a city commission and communicate with fellow commission members via my personal Gmail account. Does the public have the right to see those emails? The answer is yes, probably. If the commission members are communicating in their capacity as commission members, the emails contain government data that are presumptively public under Chapter 13. City commissions are considered government entities under Chapter 13. Under Section 13.02, Subdivision 7, government data is all data collected, created, received, maintained, or disseminated by any government entity, regardless of its physical form, storage media, or conditions of use. So it does not matter that the data was created and maintained on a personal Gmail account. If the commission members are communicating in their capacity as commission members, the emails contain government data that are presumptively public. But if the emails were sent in a different capacity, they would not contain government data. An example of this would be if two of the commission members also coached a youth sports team, and then they emailed each other about practice updates. That would not be data created in their capacity as commission members and would not be government data. So the public would not have access rights to those emails. For our next question, a government entity asks, what if a data requester says that they are unable to use our standard data request form due to their disability? Does the ADA apply to the DPA? While the Data Practices Act does not reference the ADA, state and local government entities are subject to Title II of the ADA. Additionally, Minnesota has a specific public records accessibility law. Thus, the government entity should make reasonable accommodations for this data requester. Under Title II of the Americans with Disabilities Act, all state and local government entities must make reasonable modifications to policies, practices, and procedures where needed to make sure that a person with a disability can access the entity's services. And Minnesota Statute Section 363A.42 requires reasonable modifications to any policies, practices, and procedures that might otherwise deny equal access to records to individuals with disabilities. So government entities should have procedures in place for a member of the public to make an accommodation request. If you are a government entity and you're not sure who to contact about this procedure, the person who handles accommodation requests for your employees would be a good place to start. Question 6 asks, can a government entity require me to use their online portal to submit my data request? Government entities may have reasonable procedures for accepting data requests, including the use of online portals. The Data Practices Act doesn't establish specific processes or procedures for how government entities must receive data requests, so the use of online portals are generally okay. Section 13.03, subdivision 2, requires entities establish procedures to ensure that requests for government data are received and complied with in an appropriate and prompt manner. If online portals are overly complicated or glitchy, they may not satisfy this requirement. Additionally, Section 13.025 requires government entities to document their processes and procedures in data access policies that are easily available to the public. So, if an entity's procedure is to accept data requests through an online portal, that should be reflected in their data access policies. I want to highlight a few other things to consider when using online portals to accept data requests. First, there must be a way to submit anonymous requests for public data. Next, sections 13.03 and 13.04 use the language upon request to a responsible authority when discussing an entity's obligation to provide data to data requesters. So, requests sent directly to the RA should still be honored. Lastly, as noted in question 5, entities must still have a process to meet their ADA requirements. A couple advisory opinions that might be helpful to look at on this issue are AO 03-025 and 01-036. These opinions do not address the use of online portals. However, they highlight the fact that government entities have discretion to require data requests be made in writing, and government entities can establish procedures for how data requests must be submitted. Question 7. A data requester asks, is a government entity required to send me an email acknowledging that they have received my data request? The answer is no. There is no requirement under the law for government entities to acknowledge receipt of data requests. While it may be helpful for the entity's internal procedures to acknowledge receipt of data requests, the law does not require them to do so. Chapter 13 only sets timelines for the government to respond to data requests. If you are a data requester and are unsure if the entity received your request, you should follow up with that entity. Okay, we've reached our last question and it's a little bit tricky. It says, a person, X, called our police department to report an altercation with a neighbor. The neighbor threatened X with physical violence after X asked them to be quiet. Is X's identity protected as a real property complainant under section 13.44? The answer here is no. Section 13.44 only applies when the complainant is making a complaint about a use of real property that is a violation of state law or local ordinance. In this question, it seems like the purpose of X's call was to report the threat of violence that their neighbor made, not to report a noise violation. Thus, it is not a complaint about a use of real property, and section 13.44 would not apply. Instead, this data would be classified under section 13.82, subdivision 3, request for service data. Under this section, X's name and address are public unless X qualifies as a protected identity under subdivision 17. On the other hand, if X called to report the noise their neighbor was making in violation of a city ordinance, section 13.44 would apply, and in that case, X's identity would be confidential. All right, I spoke a little fast, so those are all of our questions for today, but we'll take some time to answer your questions. Remember to send them to all panelists so that we can make sure that we see them. I have a few reminders on this slide. The slide deck is available on our website, and you can access the recording on our YouTube page in the next day or two. I'm also going to put the evaluation panel in the polling section. If you would please fill that out and let us know how we did and what other topics you'd like to see in the future, that would be much appreciated. We want to make sure that these webinars are useful to you, so thank you in advance for your feedback.
Okay, I will hop in here with the first question that we had, and so the question is: does an agency need to? Oh, it just disappeared. Does an agency need to maintain copies of data requests and responses? This is a great question. The Data Practices Act is generally silent about records retention, and so there's nothing in the Data Practices Act that specifically says, hey, you need to maintain data requests and your responses to data requests for a certain period of time. And so there's nothing in the Data Practices Act about that. However, you also do have obligations as government entities under the Official Records Act and the Records Retention Schedule, or excuse me, the Records Management Statute, which requires you to maintain a records retention schedule. So to some extent, responding to data requests may be part of your official activities that you need to have some documentation for or retain according to your records retention schedule. And so I know I've taken a look at the general records retention schedules that are available through the Minnesota State Archives in the past, and some of those general retention schedules do identify data requests as being official records that should be retained for 1 year, 2 years. So this is a really great issue to go back and take a look at your entity's records retention schedule to see whether or not you're considering responses to data requests as official records, and if so, how long those need to be retained. So it might vary a little bit from different types of entities to other types of entities, but that would be the real place to find the answer to this question on whether or not you need to maintain that response, and then how long that response needs to be maintained for.
Okay, the next question is the complainant in an employment investigation entitled to a copy of the investigator's summary of their interview statement or only their written complaint upon the closing of the investigation? So 1343, subdivision 2, paragraph D as in dog, says the complainant may access the statement that they make to a government entity in connection with a complaint or charge against an employee. So generally that might be the actual complaint that a complainant is making to sort of kick off the investigatory process. I would say a summary of the complaint is not necessarily an access to their own statement. It's going to depend on the data that you have, but they are entitled to any data that is determined to be about them. So if there are data about the complainant in the investigatory materials, they would be entitled to see that. So they are entitled to their statement and any data that's about them. So it will depend on the data that exist and that are about that complainant, but they have the right to their own statement.
Okay, the next question we have here is, if a person must provide an email to request data, can that be determined to be anonymous because they can use an email address that doesn't identify the data requester? That's another good question here. I'm just taking a look at 13.05, subdivision 12, and that's the subdivision that talks about how a government entity cannot require persons to identify themselves, state a reason for, or justify a request to gain access to public government data. But a person may be asked to provide certain identifying or clarifying information for the sole purpose of facilitating access to the data. So yeah, asking for an email address, it may not be inherently identifying, but I think a lot of folks use their personal email addresses and have their name in it, and so it might be. And so, I think the best guidance I can offer here is that it may be worthwhile on your data request forms or in your portals or whatever you're using to receive data requests. I think it's certainly appropriate to have email as a field there, but maybe not making it a required field. And then just offering up the guidance of, hey, if you don't provide us with certain contact information or other information, we may not be able to facilitate your request. And then at that point, I think you're probably meeting the letter of the law, not forcing someone to identify themselves, while also kind of being practical and saying, hey, if you don't provide this information to us, we can't actually respond to your data request. And so, there might be a little bit of a balance there on that front. But I agree that, email addresses aren't always inherently identifying, because somebody could certainly create a new email address, anonymous123@gmail.com, and certainly submit their requests that way. But I think on this front, probably being reasonable in your forms and thinking about practically, hey, what would be identifying information, and are we forcing someone to identify themselves if we require emails to be submitted? And so maybe making that an optional category, but then saying, hey, we can't facilitate your data requests if you don't provide us some information on how to contact you. So probably a balance there, but a very good question.
Our next question is, if a request is made for all data related to a matter, does that include emails? If not, if a request is made for all letters and correspondence, does that include emails? So I think one, it would be certainly fair to interpret a request for all data about a certain subject to include emails. Of course, you can always have a clarifying discussion with the requester to make sure you know what the scope is of what they're actually looking for, because maybe they don't want emails. But it is possible, and I think it's reasonable to say if somebody's asking for everything, that would include emails. Similarly, if somebody's asking for letters and correspondence, I think it's pretty reasonable in this day and age to consider correspondence to be emails, because that's how we correspond with one another nowadays. So again, clarify, have that discussion if you're not certain, but I think that it would be reasonable to interpret both of those requests, either a request for all data or a request for letters or correspondence, to include emails.
Okay, we've got a couple of questions about situations where an officer working in a law enforcement agency sounds like doing an investigation and pulls some data from databases into their reports that they're working on. And so in the first situation, we've got an officer pulling the data from the DPS database to verify an individual, notes in their narrative that the date of birth and address come from the DVS database. And the question is whether or not that information is private. Good question. When it comes to the DVS data that are in that database, that is governed by the DPPA, and Minnesota law basically says, hey, we're going to incorporate the requirements of the Driver Privacy Protection Act into state law here. And so basically we have to treat those data the same way that the federal law treats it. And so in most situations, those data can't be disclosed without some, exceptions. And so there are permitted uses for that. And one of the permitted uses is to, for law enforcement functions, or to comply with, some sort of governmental function or duties that you have to do. And so the way we oftentimes interpret this is that, responding to data requests and doing some of that law enforcement work is a government function. And so, providing access to the data in that law enforcement context, that it's in a report, that's probably one of the permissible uses under the DPPA. Of course, you wouldn't want to just go access the DVS database, upon request and provide information, only in that context where maybe it's pulled into your reports. That said, the DPPA does have some pretty high penalties if there's a violation. And so on this one, when it comes to the DPPA, that data from the database, I've certainly run those thoughts by your city or your agency's legal counsel, just to confirm that they agree and that they feel comfortable with that. I know some attorneys, city attorneys, other attorneys for law enforcement agencies say, hey, no, that's pretty strict. We would want to withhold data that we're pulling into our reports, from the DVS database, because we have concerns about those penalties. And so that's probably ultimately a legal call to chat with your attorney. The one that's similar to this is, when a police officer accesses the BCA criminal history database to obtain criminal history information, is that information still considered private data? I think, again, in this situation, you've pulled it into your report. You're not just accessing it, upon request. It's part of your report. I think it becomes part of your data under 1382. The BCA database is a little bit different because there isn't some of that federal protection and kind of those strict restrictions there. And so here, I think if you pull that criminal history, include it in some of the investigative data, that narrative that you're creating in the course of your law enforcement work under 1382. I think probably those portions of data would fall under 1382 and follow the applicable classifications there. Of course, it's a little bit different if you're running a background check or maintaining criminal history data for some sort of other reason. Then there may be limitations as what's accessible, but to the extent that you're taking it, putting it part of an investigation, I think that's 1382 data on that front.
Okay, this question is an agency allowed to only provide printed out reports rather than an electronic version by email? And if so, how do they counteract someone that wants to put in an anonymous request and is required to pay? For example, someone non-local requests calls for service for an address, and the agency is going to require the person to pay and only provides reports by paper. So there are a few things going on with this scenario and this question. One is that government's obligation is to provide access to data in the format that you maintain it. So you don't have to make if electronic data into paper. If you only have it by paper, you don't have to make it into electronic data. You don't have to scan it necessarily. That would be up to you if you wanted to do that. But in order to facilitate access to the data, whether it's paying or mailing, whatever it is, 13.05 says that we do have to allow anonymous requests, but we can ask a person to provide certain identifying or clarifying information for the sole purpose of facilitating access to the data. So if you have somebody who wants you to mail it to them, we have certainly heard people go through the process of getting a PO box and trying to stay anonymous in that way. But you can ask for some information about how to provide access to that, and that would include methods of payment as well.
Okay, I do want to just hop in here to note that we do see all the questions that are coming in, and some of the questions are really good ones, and that we want to just make sure that we go into and take a look so we have correct answers rather than just answering off the top of our heads here on some of those. So if we haven't answered your question yet, do know that we will certainly follow up with you if we don't answer it on during the webinar here. So we will follow up with everyone who's asked a question and didn't receive an answer.
Yeah, so it looks like we are about at time. Like Casey said, thank you, Casey, for jumping in. For those of you who submitted questions that we did not get to, we will be following up with you. We have your email addresses from your registration. And yeah, this video will be available on our YouTube and the slides are available on our website. Thank you all for joining.